Number 20.
The Lordships were pleased to pass an order on 19th July 2020.
State that.
Please, Manoj, Your Lordship, can you just two clarifications in this, Manoj? Lordship, a submission was made, Manoj, based saying that, Manoj, the Act has not been implemented, Manoj.
Yes, that's what the submission is made.
Correct, Manoj. I mean, actually the Act has been, is a 22 Act, Manoj, which was implemented, Manoj. Lordship, I just want to place on record, recruitment has commenced and is in the final stages, Manoj. I'll just annexure R1 of the statement of application for vacancy. R5, Manoj. R5, Manoj. KPSC has total number of notification issued was 24. Karnataka Examination Authority 18, Manoj. Totally 42. And total number of posts which were thought to be filled up was 3,644. My only request at this stage is, Manoj, R5, Manoj, page 32, Manoj. Because after hearing your Lordship a partial interview, can I make one request in this? Page R5, page 32, Manoj. Consolidated statement, name of recruitment agency, that is Karnataka Public Service Commission, 2 is Karnataka Examination Authority. Total number of notification is 24 and 18, 30, 42. Total number of posts is, Manoj, it comes up to 3,644. Number of notification with 56% reservation is 42, Manoj. Number of internal, yes. Therefore, Manoj, may I request, Manoj, the order, because we are filing this, we should not be in contempt of your Lordship's order, Manoj. Let it be only saying that your Lordship's order will be operative. No fresh notification will be issued till your Lordship's here immediately after vacation.
No, has the recruitment taken place?
Yes. Going. R6 and R6 may be kindly. Page 33, Manoj. Can I request page 33, Manoj? Industrial Extension Officer, number of 50, notification is 15th March 2024. 15th, all serial number 15th March 2024. Various departments and posts much prior, Manoj. Nearly 42 departments, Manoj, for nearly 4,500 has been done, Manoj. And we have completed. Can I share this with your Lordship?
Has any appointment been made?
Yes, Manoj. In respect of this, and these are the completed record. Well, only because it's my duty to bring to your Lordship. These are the consolidated where selection process that is pending. These are the completed, Manoj. Recruitment got completed with 56%. Manoj, your Lordship, what we pointed out to your Lordship's, Manoj, on basis is. That is 4,409, Manoj, of different bus conductor, BWSSB, tools, Raichur University, all this has been completed, Manoj. What annexure R5 is almost in the date of completion. Can I make one thing, Manoj? We will not issue fresh notification, Manoj, till your Lordships, and we will not complete.
May I make one submission? I appear for the respondent in item number 20.2. There, Manoj, before the KAT I succeeded. Recruitment notification itself has been quashed, and no recruitment has taken place insofar as the gazetted probationers are concerned. And this honorable court notes in 20.2, after hearing the government, what the interim direction issued is that selection process can continue, but results shall not be announced without leave of this honorable court. That is the interim order granted in 20.2. Therefore, Manoj,
That is the date of the order is?
Date of the order is, Manoj, 31st July 2025. That is a writ petition filed by the state, Manoj.
Can I read it? notice so and so, learned additional advocate general so and so, assisted by so and so, direct to serve a copy. Then an interim order, it is provided that the Public Service Commission may go ahead with the selection process. However, the result of the selection shall not be commenced without the leave of the court. That is regarding one appointment, my lord. One recruitment, my lord. That we are adhering. We are not seeking any modification of this order, my lord. We are not touching on
a similar order has been passed in a writ petition where we have challenged the recruitment notification issued by the BBMP. The authorities selection, I do not know which are the appointments they have issued. Really.
Question now is, as far as those two matters are concerned, whether there is an interdiction, they obviously can't do it. As far as this order of staying the notification which we passed on the last occasion, some recruitment they say has already taken place.
Yeah. My lords, in identical circumstances, my lords are aware. In Justice Lakshman Patil, when the Bombay High Court had approved the selection, the recruitment, the reservation in favor of Marathas, in spite of it, 3-judge bench of the Supreme Court, while they're referring the matter to Constitution bench, it stayed the reservation in excess in favor of Marathas and ordered that since it has been operated only in one academic year, it shall not be given effect only for the current academic year and also for the appointments.
That's what he's saying. No further.
What they are saying is further notification. My lords may say not. Wherever appointments have been made, it is fine. But wherever it has not been made, because when they said the selection list has been finalized, thereafter, even after selection list is published, it takes 2 to 3 months to make the appointment because thereafter the reservation certificates have to be verified through district caste verification. My lords may say, my lords, this interim order shall not operate wherever the appointments have already been made under the new act.
Can I make one suggestion, subject to your lordships? I'm appearing. I'm so sorry. Yes.
See, as far as what will happen in the meantime to those notifications, because otherwise the propensity will the whole.
Those notifications, my lords, those notifications. What will happen is the similar interim order as in the 20.2 and in that BBMP's case, selections if they have made, let them not operate it because ultimately, my lords, if the reservation to the extent of 56 or 57%, if my lords set aside, thereafter the entire reservation matrix will have to undergo a change. That means even wherever there is more multi-stage selection process, like for example, there is a preliminary examination, then competitive examination, then interview. In all such cases, even the eligibility list for the second and third stages of the recruitment process will have to be redrawn, and it will have to be redone afresh. Therefore, it will be chaotic conditions. Therefore, my humble request to my lords is this: wherever appointments have been made, it will be subject to the natural emergency. It will be subject to the outcome
of the appointments. Whatever process is begun, if they're saying some notifications have already been issued and part of the process has already begun.
That process, let it continue, my lords, but let them not issue orders of appointment because within 3-4 weeks, my lords are going to decide this matter. Because it is a pure question of law. Ultimately, my lords, what they say is we have taken Justice H.N. Nagmohandas report and on that basis we have given the reservation in excess of 70%. My lords, our submissions are simple that Justice Nagmohandas report has fundamentally erred in applying the test of adequate representation, and it has gone by proportionate representation, number one. And even in a tribal area, Constitution bench has said in respect of the Andhra scheduled areas system, the no reservation even in tribal areas can be contrary to Article 16(1). And it will be a violation of this one. Therefore, the 100% reservation there has been set aside. And even in respect of tribal areas, Supreme Court has now said that it is only 50%.
We're only talking about what will happen in the interregnum period.
Interregnum period, my lords, as long as there is a time bound.
None of those two cases, notifications was challenged. The nature of interim order here, none of these notifications have been challenged, my lord. All the notifications.
Can I just make this suggestion, my lord? I don't mean to interrupt the advocate general.
Yes.
My lord, to has exceeded 50%. Prior to this, impune notification, it stood at a certain level. Today, if the recruitment process were to go back and say that we will complete as per the pre-impune notification, I think that would suffice the exigencies of the service. Therefore, my submission is only to that limited extent between 48 to 56, that 8%, let them withhold it. The remaining post can be filled up as per the earlier notifications.
That is not possible. That's the problem. Your Lordship, can you see my learned friend? There's no impune notification in this. What is sought to be challenged is the act. So what we are.
What you tell us is once the act is struck down.
See, identical. Supreme Court said go ahead with the appointment process. Even where cases have been struck down. I'm sorry.
I have produced a judgment to the contrary that Supreme Court don't beyond 50% you cannot proceed.
No, I'm with my learned friend. Supreme Court has said that you can do above 50%. Where it was struck down, para 4, Your Lordship may kindly say, we therefore permit the state to go ahead with the selection process and make appointments and promotions. However, it made clear the same shall be subject to the result of the petition. All appointments and promotions orders shall specifically mention such appointments and promotions are subject to the final outcome of the present proceeding.
That is for Jharkhand.
In this case, it is struck down. Now we are at the interim stage. Even after being struck down, this is what the interim order was passed. I'll be able to Supreme Court, in Indrasani as well as Marak.
This is in the
Chhattisgarh case, where it was struck down.
No, but this is only for one notification.
No, for all by the state. Your Lordship may kindly see. Your Lordship, page para 1, if I may request. So and so appearing for the state submit before the judgment High Court was there. Various departments have issued selection process. Were also in the process. It is submitted the petition on go ahead with the selection process. The same so and so. So therefore, the act was set aside over there. Now we are at the interim state. Therefore, I'm only saying that we will comply with your Lordship, not issue fresh notification. Whatever we have done, because we are at the interim stage, permit us to complete. Let the same conditions what your Lordship. Let this.
Or will be all will be subject to the outcome.
Yes, please, my Lord. Your Lordship may.
Then you will have to revert back.
No, the reason the Supreme Court in para 810 and 860 they said it can be above 50. And Maratha, my Lord, the question is
whether it can be one.
By way of interim order.
Therefore, my Lord, the petition Act of 2022, 2021, 2023 petition, my Lord.
Chhattisgarh case was different.
Your Lordship, may kindly see, petition is filed after 3 years, my Lord. In 2025 petition, my Lord, filed after 3 years of the Act coming into force.
No.
All these notifications, all these notifications of the year 23 and 24, my Lord. So therefore, my Lord, Your Lordship, back.
My Lord, insofar as we are concerned, notification was issued in.
No, we are not asking for modifying my learned friend's case. In each notification, will comply with the order which is already there. Only concerned with the order your Lordship passed last week, my Lord. Only on that, my Lord. Rest of the orders which are there, let it.
Instead on creating third-party rights on interim order, adversarial rights, a matter could be heard and disposed
Yes,
of.
we are all ready. It can be heard today, tomorrow.
Yes.
Unless AG has any objection to that.
This is an application filed on behalf of respondent number 3 and 4, bracket state. We will link with the modification number 4, modification of the interim order. Mr. Sheffield Bennett, Counsel, AG appearing for the said respondent submits it prior to the order dated 19/11/2025. The recruitment process notifications have been issued for undertaking recruitment, and the recruitment process has begun. Good stuff. The application also includes an annexure where the recruitment process is under progress as on 20/11/2025. submits that if the said process is interdicted, then there would be then the state would suffer a shortage of manpower. He also refers to the decision, interim order passed by the Supreme Court in Yogesh Kumar Thakur versus Guru Rasidas Sayya and Awam Sanskriti Academy and others. This order dated 1/5/2023. Whereby as an interim measure, the Supreme Court had observed and permitted the state to go ahead with the selection process and make appointments and promotion. However, the same would be, I clarified that the same would be subject to the result of the petition. Additionally, the Supreme Court had directed that all appointments and promotion orders would specifically mention that such appointments and promotion are subject to the final outcome of the proceeding. Full stop. He submits that is similar with the interim order dated 19/11/2025 be modified the aforesaid extent. Full stop. Also clarifies that where there are specific orders passed in respect of notifications by the court or tribunal, the same would be honored and the modification as suggested would not cover the same.
There is a
Full stop. We find, given the extent of recruitment being undertaken pursuant to the in conformity with the Act. Conformity with the service, the education institution under the Karnataka Scheduled Caste and Scheduled Tribes bracket reservation of seats in education institution. Appointments of posts and services under the State Act 2022. Consider it. Opposite to modify our order dated 19/11/2025. To direct that no further notifications and in conformity with the reservation in excess of on the basis of the increased reservation under the Act would be no further notifications for recruitment or appointment. Would setting out on the basis of increased reservation would be issued till the disposal of the present petitions. However, the recruitment pursuant to the process that has already begun may be continued. However, any appointment or allocation of seats shall be subject to the final outcome of the present petition. All appointment letters would, all appointment / promotion letters would expressly indicate that the appointment and the promotion is subject to the outcome of the present petition. And the candidates would not acquire any right,
they can
In the event,
not claim any equity.
in the event they lose,
do not claim any equities. Also, in the event the increased reservation is struck down. Stop. Listen. Now,
Yes,
the
sir.
petitions will
we'll file our objection.
But this will not affect the other recruitments, my lord. He is only seeking for a change in only that particular. Other interim orders granted by this court will not be affected. Kindly,
We also clarify that
kindly.
the present order is only confined to modifying the order dated 19/11/2025.
Specific interim
And
order.
would not affect the operation of any other specific interim order or final order granted, granted by any court or tribunal.
Please. 2 weeks to file an objection in January, some date. If you want.
We are ready anytime.
In the mean petition, Justice Leonard Legge seeks further time to file its objections. Let the same be filed within the period. How much time would you want?
2 weeks.
To wait. Seeks 2 weeks time to file the statement of objections. The rejoinder, if any, let the same be filed within the set period. Rejoinder, if any, be filed before the next date of hearing. List on to the end of January. Then for the 20th January, the date is 20th January. In the meantime, the council shall also file the written submissions along with all authority relied upon by them.
Just 3 judgments, Maratha,
All
Indra
state.
Sahani, and DWS.
Maratha is state.
Maratha is complete not statement. It is what Maratha, the difference between Maratha and scheduled caste and Maratha decided you can't give reservation. Here, because your majority and proportionate representation is there. Whereas this is a case of increase of reservation. The difference is there.
No, you are saying the decision is Maratha. Jivijira,
Please,
that the Maratha
that has
reservation.
been set aside.
So it is pending before the Supreme Court.
No, it's
before
set
the
It's set
High
aside.
Court.
Set aside. Supreme Court is set aside.
No, that's the first round. What about the second round?
I'll just verify. I'm sorry.
I thought that was a remand back to the court.
No, it is set aside saying that they cannot in the para 660A of Maratha main judgment. I'm not aware. Saying that there cannot be reservation for Maratha at all.
Please find out, we may be under wrong.
Maratha reservation, Jayashree Patil stands even today.
Correct. I vote on to that. Saying that Maratha
There it is said that
can I read that one
it cannot be
paragraph?
given.
There is another matter pending.
I'll verify that. I'm sorry, Manoj. I'll just verify
The
that.
second round is pending, my lords.
There was a second round because there was a constitutional amendment there.
Yes, my lords.
The constitution
The second
amendment-
round is pending.
This is when 105th constitutional amendment was not.
Yes, there only identification of backward classes by the state.
Based on the 102nd constitutional amendment. After that comes the 105th constitutional amendment where it again gives power back to the state.
I fully here, Manoj.
In 102nd, there is
I'll just verify. I'll go.
the power was under similar to SC and ST.
Article 338, 336, 337, 338, Manoj.
No, clause 9 of those
I'll verify.
articles was similar in 338B as well, which was for the backward class. Then under the 105th constitutional amendment, that clause's reference has been deleted.
I'll just check. Look at the second Maratha.
Check it.
I'll check it up and then come back.
But there is
We'll
a
find a
one,
written submission, synopsis and judgments, whichever is.
there is one matter before learned single judge challenging the very same act. Therefore, my lords would withdraw it to the dispute,
Challenging the act.
challenging the act.
Let me be.
That may be tagged on and it may
Second
be
set
brought
may be
here.
filed in that order.
We'll find.
Yeah, we have no objection.
When is that listed?
Yes, my lords.
When is that listed?
That is 18th of December is the date given there, even if it comes.
The other
Case
issue that you require to see that one of the grounds of challenge is that
25. Yeah. 25515. 2020.
second thing is that the clause 9 of article 338 and 338A,
Consultation.
consultation.
Please, that was, in fact.
Clause
just to
9 of the-
mention, correct. That has also been dealt in this judgment, Maratha. I'll look into that.
All of this stuff. Cabinet Council state that it is
Oh, it's in Kalburgi,
not
High
a
Court.
petition being.
Kalburgi, Delhi road.
Bengaluru.
This bank, 25,000 people.
The number looks like Kalburgi.
25,550.
Huh? 2000448.
Yeah, that has been already transferred here.
States a petition.
25,515.
That's WP number would be 25515. What is listed today is 2000448.
That has already come here.
Yes. That has
Now
to be
25515 has to be tagged on.
Another petition, 25515 of 2025. Challenging the vires of the Act 1 of 2025. This is a present appeal. This is a present petition. Let the said petition be also listed along with the present petition.
Please.